So you don't need, pag sinabi mo kasi authenticate, you have to prove the genuineness and due execution of that particular document. Now, it is only a private document that needs to be authenticated for it to be offered and to be admissible in evidence. Now, if it is public document, no need to authenticate it. Now, what about an electronic document? Please, an electronic document is considered as a private document, and therefore it has to be authenticated. An electronic document is considered as a private document, and therefore it has to be authenticated. Now, lumabas yan sa bar 3 or 4 years ago. How do you authenticate an electronic document? You have to know how to authenticate, kasi nga ang basis niya, it is a private document, and therefore for admissibility, as a rule, it has to be authenticated. So how do you authenticate an electronic document? It is so provided in the e-commerce law. Number one, by evidence that it has been digitally signed by the person purported to have signed the same. Evidence that it has been digitally signed by the person purportedly who signed the same. And number two, or by evidence that other appropriate security procedures or security measures have been adopted. Appropriate security measures have been adopted to show that the integrity of that particular document was preserved from the time it was generated, electronically generated, up to the time it is received or presented to the person to whom it is addressed. Okay, security measures have been adopted from the time it was electronically generated. Remember, it is considered, an electronic document is considered as a functional equivalent of an ordinary written document. It is a functional equivalent. So pareho rin siya. So since it is considered as a private document, you have to know, you have to authenticate that for purposes of its admissibility. Okay, now, functional equivalent under the best evidence rule. Now, another point to remember as far as the electronic document is concerned, Lisa decided na ito, when you talk about electronic document, it must be paperless, not paper-based. Electronic document is paperless, not paper-based. That is why in one case which was decided, it's a Sangyong Corporation in Korea-based corporation. It's a 2007 case where the Supreme Court said that an electronic document is paperless, not paper-based. In other words, that is why, kasi they transacted, Philippines and Korea, they transacted via fax machine. Sabi ng Supreme Court in that case, the fax transmissions are not considered as electronic document. They may have been electronically transmitted kasi sa fax machine. However, they are still paper-based. Kasi di ba ipapasok mo yung paper, it comes out paper also doon sa addressee. So it is paper-based. Fax transmissions are not electronic documents under the rule because they are paper-based. Now, ano daw yung paperless? Yung mga email. That is an electronic document. Because it does not use paper. It can still be printed, but it does not use paper for purposes of transmission. Okay. Now, what about yung text messages? Text messages, telephone conversations. These are considered as ephemeral electronic communications. Hindi pa lumalabas yan sa bar, no? Ephemeral electronic communications. Yung text messages and telephone conversations. Now, please take note, ephemeral. Pag sinabing ephemeral, temporary lang yan. Temporary. Meaning, pag sinabing ephemeral, it cannot be preserved. Kaya lang, parang feeling ko, nagkamali yata as far as text messages are concerned. Di ba it can be preserved dun sa inbox? Pero in two cases, in at least 2 cases, text messages were considered as ephemeral, electronic. Electronic kasi generated, no? Electronically, do sa text, no? Okay, but they are considered as ephemeral. Ephemeral nga, temporary. It cannot be preserved. And yet, dun sa 2 cases na yon, kinonsider yung text messages as ephemeral, electronic communications. But doon sa 2 cases, these are 2 admin cases. These are 2 admin cases. Yung Zaldinuez case, at saka yung Magtolis versus Salud. These are 2 admin cases where the text messages were admitted. Not because hindi nag-rule, there was no definitive ruling by the Supreme Court that as to the admissibility, why it was admitted, yung text messages. They were simply termed as ephemeral electronic communications. Why were they admitted? In other words, yung angle of admissibility, hindi tinatch doon sa admin na yon as an electronic document, as an electronic evidence. It was admitted because it was identified. It was acknowledged to have been sent by the one who actually sent it. Kung walang admission yon, hindi inadmit. For purposes of that, determining his administrative liability. In other words, dun sa particular 2 cases na yon, na administrative, hindi dinetermine, no definitive ruling by the Supreme Court as to the technical aspect. Why was it admitted? Why was it admitted? It was there. So, ang pinalabas lang doon, it was admitted, yung text messages were admitted as evidence against the respondent in that particular administrative proceeding, admitted because it was established by testimonial evidence that it was he who sent the message. Kasi dun sa message, magkita tayo, magdala ka ng 1 million pesos, because he was looking, yung plaintiff dyan, yung complainant, was looking for somebody to expedite the resolution of his case. Remember, these are 2 cases involving 2 CA employees. Court of Appeals employees. Yung isa asking for 1 million pesos for the resolution, favorable resolution in favor of Zaldinuez, who simply wanted that this resolution of his case, which was dragging on for several years, the resolution be expedited. Yun lang ang hinihingi niya. Tapos sabi sa kanya, okay, I found someone sa text. I found someone who will not only expedite resolution of your case, but who will make a favorable decision, but for a fee. Sabi niya, let me think about it. He did not think about it. He went to the NBI and they set up an entrapment. He went to the NBI. That's it. Okay. And then he texted back. Text eh. He texted back. Sabi niya kaya, okay, I agree. Sabi ng babae, yung babae itong CA Division Clerk of Court yan, ng Court of Appeals. Dismiss na yan. She was found administratively liable. Sabi niya, okay, kita tayo sa Jollibee. Sa Ermita. Ang lapit, no? Sa CA. Bring the money. And I will give you the resolution. They agreed. Okay, pagdating doon, huli na siya. Entrapment eh. Now, they used, initially, I do not know what happened to the criminal case, no? But initially, they used, kasi hindi ginamit ang text messages, hindi pa admissible sa criminal case. Okay, they used the text messages in the admin. Tinanong siya, sa'yo ba itong number na to? Yes. Ikaw ba nagpadala nito? Yes. Inamin niya eh. So she was found administrative liable. Hindi rin niya nakuha yung 1 million. Entrapment nga eh. So, what I'm trying to say is, yung isa naman, CA, employee, hindi official. Text sa boss. Ma'am, hindi ako pwedeng pumasok. Hindi ako makakarating. Until finally, na-awol siya. Kasi text. Imagine magte-text siya sa boss niya lagi, na-absent siya. Okay, nawili. So, inawol. Okay. So, during the proceedings, admin proceedings, dahil na-awol siya, he admitted that he was sending those messages, text messages. So, kaya lang inadmit yun because in-acknowledge. But there was no definitive ruling by the Supreme Court as to the admissibility itself, technical admissibility of the electronic, of the text message. Parang sinasabi lang doon, it is admissible because it was established to have been sent to and received by the addressee. Pero kino-question ko ngayon kasi, para naman walang cellphone yung mga justices. Kasi ephemeral. Ephemeral is temporary. It cannot be preserved. Yung text messages na be-preserved kaya yan. Diba? Kaya ingat kayo dyan. Ako kasi nag-preserve. Okay. Now, the rule is, private documents would need to be authenticated. You have to establish the genuineness and due execution of the private document. That is a rule. Before it can be offered in evidence. Exception is if the private document is more than 30 years old, which does not bear traces of alteration. Naninilaw na siya, not because it is written on yellow pad, but naninilaw na siya because of the time. More than 30 years old, it does not bear traces of any alteration. And number 3, it is found in the causative one, in whom it may be naturally found if it were genuine. That is a private document. But since it is more than 30 years old and executed, or in the condition as more than 30 years old, no traces of alteration, and is found in the causative one, in whom it may be naturally found if it were genuine, that is admissible even without prior authentication. Do not forget the ancient documents rule. Ancient, that's an exception to the need to authenticate a private document if it is an ancient document. Ancient document rule, matagal nang hindi lumalabas sa bar. Next. Now we go to testimonial evidence. Tandaan ninyo, as far as testimonial evidence, you talk about competence. Initially, you talk about competence. So, tandaan ninyo yung difference between competence and credibility. A witness may be competent. He is allowed to testify. Now, pag nag-testify siya, it all depends on whether his testimony is credible. It depends on whether his testimony is credible. He may be competent, in which case, if he is competent, remember that the determination of the competence of a witness is made at the time the witness is called to the witness stand. The competence of a witness is determined at the time the witness is called to the witness stand. Kasi at the time the witness is called to the witness stand, i-offer ang testimonian. Di ba, when do you make an offer of testimonial evidence? At the time the witness is called to the witness stand. Okay, when the witness is called to the witness stand, you already make the offer of the testimony of the witness. Remember, you do not offer the witness. You offer the testimony of the witness. I'm calling to the witness stand, Mr. X, Your Honor, and I'm offering his testimony for the following purpose. For every offer of any piece of evidence, state the purpose for the offer. So at the time pa lang the witness is called to the witness stand, o-objekan na yan. Disqualified yan. For example, Your Honor, I object to the presentation of this witness because this witness is disqualified under the marital privilege rule. Okay. Or is disqualified maraming disqualification. Under the dead man statute, if one is one of the purposes of the offer. So it is determined sa purpose of the offer at the time the witness is called to the witness stand. Okay, so when you talk about competence, tandaan nyo, competence is the fitness of an individual to testify. Kaya nga, once he's called to the witness stand, titignan kung pwede siyang mag-testify. Competence is the fitness of an individual to testify. So when you talk about competence, you're talking about what? Qualifications. Tandaan niyo yan, When you talk about competence, you're talking about qualifications. Next point. What are the qualifications of a witness? For a witness to be able to testify, what are his qualifications? Ang rule, all those who can perceive and perceiving can make known their perceptions to others may be witnesses. Okay. Number 1, therefore, the witness must be able to perceive. How? Through his senses. And number 2, after he has perceived, he must be able to relate what he has perceived to others. Dalawa ang qualifications in order for him to be a witness. He must be able to perceive how through his senses, and number two, and ito, he must be able to relate what he has perceived to others. Yun ang qualifications, yun ang competence. So competence is the fitness of a witness to testify. Competence relates to qualifications. And the qualifications are that he must be able to perceive and he must be able to relate what he has perceived to others. Now, if he is found to be competent, he will be allowed to testify. Now, ngayon, yung i-determine in the course of his testimony and upon evaluation of the testimony, when the case is submitted for decision, if the testimony is credible. So, credibility is not immediately determined. Okay, credibility now, what do you understand by credibility? It is the quality. Credibility is the quality of the witness that renders his testimony worthy of belief. So competence, fitness. Credibility is quality. Quality of a witness that renders his testimony worthy of belief. Credibility, believability. A witness may be competent. He is fit to testify. But it does not follow that the court will give weight to his testimony. It does not follow that the court will give credits to his testimony. Gets niya? Okay. Now, sabi niya, qualifications. Now, what are these qualifications? Marami, di ba, under the rules. Meaning, a witness cannot be allowed to testify if he falls under the disqualifications. Now, please, number one, very important, one important disqualification is disqualification by reason of immaturity. Disqualification by reason of immaturity. But however, under the child witness examination rule, the competence of the child is now presumed. Diba? Remember, the rules of evidence have been revised as of 1989 pa. Okay, so nandun sa 1989, if the child is immature and cannot, the child may have perceived, but he cannot truthfully relate what he has perceived to others, he is disqualified. That is disqualification by reason of immaturity. Pero ngayon, by reason of the child witness examination rule promulgated in 2000, take note please that a child witness is now presumed to be competent. Now, whoever assails the competency of the child, although kaya nga disputable itong presumption na to, but the presumption now is in favor of the competence of the child. Set na yan under the child witness examination rule. Now, whoever assails the competence of the child to be a witness has the burden of proving. Dati, before the child witness examination rule, di ba the court determines, and the court is under obligation to determine whether or not the child is competent. Ngayon, hindi na. Set na yan. Now, if you want to question, you're the one assailing the competence of the child, you're the one now trying to dispute the set presumption, which is disputable in nature, under the child witness examination rule, then the burden is on you to prove that the child is incompetent. So, set presumption na yan. Okay, now, another important disqualification, please, is disqualification by reason of mental incapacity. Very important ito, please. A disqualification by reason of mental incapacity. Kasi, when do you determine? As I said, no? When do you determine? Those whose mental condition at the time of their production for examination is such that they are incapable of intelligently making known their perceptions to others. You be careful with this, as I said, tandaan nyo, ang dinidetermine once the witness is called to the witness stand is competence, is fitness, is his qualifications. Now, one of the disqualifications is at the time of the production of the witness, at the time of the production for examination, The mental condition is such that they are incapable of intelligently making known their perceptions to others. Tandaan ninyo, i-determine at the time of their production for examination. When is that? When is a witness produced for examination? Hindi ba at the time the witness is called to the witness stand? If at the time of the production of the witness for examination, at the time the witness is called to the witness stand, sira ang deng-deng ng tok-tok niya, oras mismo, hindi siya pwede competent to testify. I do not know if you remember, your example, your illustration. Somebody, a crime is taking place. Everybody saw the witness, right smack at the crime scene. Okay. Kitang-kita niya yan. So, in any possible prosecution, in any subsequent possible prosecution, based on that incident, siya ang talagang tatawagin to be a witness. Because while the crime was going on, nandun siya at the crime scene, viewing. So, he is the most, he could give an eyewitness account of the incident. A month after, or subsequently, criminal prosecution, information was filed in court. Okay. At the time he is called to the witness stand, at the time he is called to the witness stand, he was laughing, he was crying, he was dancing. Obviously insane. But he was the one who saw the incident. At the time he was witnessing the incident, he was saying, he was simply amazed at what was happening before him. But at the time he was called to the witness stand to testify and give his eyewitness account, kasi siya pinaka-logical siya pinaka-probable because he can give an eyewitness account. At the time he's called to the witness stand, he was obviously insane. Question, is he competent to testify? Lay ako ng basis. Hindi! Di ba? Ang telling, niya dyan is at the time of his production for examination. When is he produced for examination? At the time he is called to the witness stand. If at the time he is called to the witness stand, kahit na nakita niya talaga, everybody saw him there at the crime scene. But at the time he is called to the witness stand, sira ng deng-deng ng tok-tok niya. He is incompetent to testify. Okay, balik na rin natin. At the time of the occurrence of the incident, at the time of the occurrence of the commission of the crime, that person was there. But nisasaksak yung victim, nagka-clap pa siya. Kumakanta pa siya. Hallelujah, hallelujah. Obviously insane at the time, but he was there. So probable eyewitness siya to the incident. Subsequently prosecution. Siyempre siya nakita nandun But at the time na nangyayari, nagka-clap siya, kumakanta siya na hallelujah. Obviously insane. So he's now called to the witness stand. At the time he's called to the witness stand to testify on the incident, which purportedly was witnessed by him because he was right there at the time of the commission of the crime. At the time, sane na siya, naka-coat and tie siya, naka-mousse siya, naka-gel siya. Sane na sane. Pagdating niya dyan, question, is he competent to testify? Yes. Yes, kasi sane na siya. Okay, but his credibility now will be affected. Kasi sira ang ding-ding ng tok-tok niya at the time it occurred. So what will he testify on? But at the time he's called to the witness stand, remember we are talking about fitness, qualifications. If he may have perceived, but is he able to relate what he has perceived to others? So, at the time, okay siya, magre-relate siya. But what will he relate? Siyempre magkukonjure na yan. Because at the time, hindi niya alam what happened. But at the time he's called to the witness, okay na siya. So, he is competent to testify. Gets niya? Very important siya. Okay, next. Another important disqualification, please. Disqualification between the spouses. Dalawa yan, Do not forget. There are two disqualifications between the spouses. Number one, disqualification by reason of marriage. That is the marital disqualification rule. And disqualification between the spouses because or by reason of privileged communication. Disqualification by reason of privileged communication and disqualification between the spouses by reason of marriage. Tandaan lang ninyo, if it is the disqualification, meaning the spouse cannot testify for or against his or her spouse without the consent. So please, kung may consent, wala kayong pinag-uusapang disqualification. It is only when there is no consent for the spouse to testify, then you can bring in the disqualification to bar the spouse from testifying. Okay, so under the marital disqualification rule, the disqualification between the spouses to testify for or against each other, if there is no for or against the affected spouse, if there is no consent, that disqualification is because they are married. Therefore, since that disqualification is because they are married, kasi yan, to preserve daw the harmony between the spouses. Daw, kung may harmony. Ang presumption, to preserve. Now, therefore, if the disqualification is by reason of the marriage, because they are married, kailangan magte-testify ka at will affect the spouse involved in the litigation, hihingi ka muna ng permiso from the spouse to testify. Okay. Now, since the disqualification is because they are married, therefore, that disqualification subsists only during the marriage. That disqualification subsists only during the marriage. Please, it must be a legitimate marriage. Hindi yung bahay-bahayan lang. Yung nikasal sila talaga. It must be, the disqualification lasts or subsists only during the marriage. Which means that if their marriage is terminated, let's say by annulment, by declaration of nullity of the marriage, then excess na sila, diba? So there is no more disqualification. There is no more disqualification. Because the disqualification is only because they are married. At the time, the spouse is supposed to testify. Gets niyo? Now, on the other hand, if the disqualification between the spouses, so married sila, no? If the disqualification between the spouses is because of privileged communication, meaning that he is disqualified from testifying for or against the other spouse without securing the consent of the other spouse, not because they are married, but because of the privileged nature of the information. Privileged nature of the information relayed by one spouse to his spouse. Kasi ang basis niyan, mag-asawa sila. So, if I'm the spouse, I relate something to him in confidence. It was intended to be in confidence. That spouse of mine cannot testify on that privileged, confidential matter without first getting my consent. Because I gave it to him in confidence. So, my disqualification is not because we are married, but my disqualification is because of the privileged nature of the information I gave to him. Gets niya? But it affects, that disqualification affects the spouses. Which means that, therefore, if the disqualification between the spouses is because of the privileged nature, not because of the marriage, but because of the privileged or confidential nature of the information relayed by the spouse to his or her spouse, then that disqualification subsists even after the marriage. So kahit na na-terminate ang marriage ninyo, you still have to get the consent. Now, kailangan lang, it was intended to be given in confidence. It was intended to be given in confidence. Remember yung sinabi ko, the spouses entered a bistro, cafe. Sosi tayo. Okay, hindi ka rin dariya. Pagpasok nilang ganyan, they were there. Sabi niya, honey, I will tell you something in confidence. I will tell you something in confidence. Meron tao who is an Uzi in the other table. Sa public place, he overheard it. That matter matter which the spouse gave in confidence to his spouse. It was overheard by an Uzi zero, in the other table, since it was a public place. Question: did it lose its privileged character when it was overheard by the third person? Did it lose its privileged character as to no longer disqualify the spouse from testifying on that information given to him in confidence by his spouse? Given to her in confidence by her spouse? No, it did not. The disqualification subsists. Why? Kasi nag-a-apply sa kanila eh. Di ba? Disqualification between the spouses. And it was really intended to be confidential. Now, question: is the third person who overheard that information given to the spouses in confidence, is he disqualified from testifying in what he heard? Because of the privileged nature, is he disqualified? No, he is not. Because the disqualification is applied only to the spouses. He is not disqualified from testifying. The question is, will he be credible? Yun, ipoprove niya. So, yung disqualification does not apply to this third person. For as long as it was given in confidence by one spouse or other, disqualified sila from testifying sa kanilang dalawa. What if, nandun, in the same scenario, nagpunta doon sila sa bistro, sa restaurant, tapos, public place, sabi ng husband, honey, dear, sweetie pie, I'm telling you this in confidence. Secret ito, Secret! Obviously, it was not given or intended to be given in confidence. Is he disqualified from testifying even if it was overheard? No. Kasi hindi naman intended to be given in confidence. Importante yung confidence confidential. So kailangan secret, di ba? Sinisigaw mo na, it was never intended to be given in confidence. It was never intended to be privileged in the first place. Okay, next. Please, importante, itong dead man statute. Ito di ba? Section 23, very complicated. I-simplify na lang natin, no? When do you invoke the dead man statute? When do you invoke the dead man statute? There is an action involving a claim against the estate of one who died, against the estate of one who died, and one who died or who became insane, hopelessly insane. It is a claim against the estate of one who died or who became insane. That action is filed against the executor or administrator in a representative capacity. It involves a claim. Now, in that situation or under those circumstances, in an action involving a claim against the estate of one who died or who became of unsound mind, ito yung hopelessly insane. Who is disqualified from testifying? Who is disqualified from testifying? It is the plaintiff. It is the claimant. Why? Kasi itong dead man statute, it is placed there for the protection of the estate of the person who died or the person who became of unsound mind. Kasi patay na yan. Sira na ang ulo niyan. How can he dispute? Yun Because if somebody dies and you're claiming, and then anybody can claim, lalo kung mamatay ang ayala. Ay, naku, mistisa ako, kamag-anak ako niyan. So I am entitled to inherit. Hindi. Kaya nga nilagay yun you're barred if it involves your claim. With respect to what? So, who is disqualified from testifying? It is the claimant. Or the person in whose behalf that case is particularly prosecuted with respect to the claim against the estate of one who died or one who became of unsound mind. But he is not disqualified from testifying on anything. He is only disqualified disqualified from testifying on a matter of fact occurring before the person died or before the person became of unsound mind. Kasi on a matter of fact that actually pertains to that decedent or pertains to that insane person, which can no longer be disputed. Yun lang. You cannot testify on that point, which can no longer be disputed by the person who died or by the person who became of unsound mind. Kunyari, for example, I am the claimant. I am on the witness stand. I cannot be barred from testifying in support of my claim, establish ko yung right ko, etc. But I am barred from testifying, sabi sa rules, on a matter of fact occurring before the decedent died or before the person became of an unsound mind. Kasi yan, hindi na madidispute. I am on the witness stand. I cannot say that. When he was alive, Mr. X told me that once he dies, I will inherit his 1,000 square meter house and lot in Ayala, Alabama. Hindi Ayala, Muntinlupa. Ayala, Alabama. Super rich kanyan. It is a claim against the estate. And I say, during his lifetime, in a conversation, he told me, he assured me that once he dies, I will inherit his very expensive property in Ayala, Alabama. I will be disqualified from testifying on that point because nobody can dispute that anymore. Because I am now attributing something to somebody who is already dead and can no longer dispute. Yun ang dead man statute. But I will not be disqualified from testifying on any other matter, which can be disputed. Kasi sabi, mag-establish ko ng relationship ko, etc. It can be disputed. Yun lang matter na hindi na madi-dispute because it pertains to the person who died. Alangan man tumayo yung patay. At sabihin, huy, hindi ko sinasabi sa iyo yan. Gets nyo? That is the purpose kasi of the dead man statute. The claimant cannot testify on any matter of fact occurring before the decedent died or before the person became of unsound mind. Ganun lang kasimple yung dead man statute. Gets nyo? Okay. Importante pa na, attorney-client. Okay. Yung, physician, patient, walang, attorney-client, itong attorney-client pala, let me just call your attention to this, no? An attorney cannot, attorney to, hindi attorney. Attorney cannot, ang sakit sa tenga eh. An attorney cannot, without the consent of his client, be examined as to any communication made by the client to him or his advice given thereon in the course of, in the course of or with the view to professional employment. So, it is not only limited, the disqualification for the lawyer from testifying on any matter that was related to him by virtue of the client is not only with respect to matters in the course of a lawyer-client relationship, but even with the view to, meaning, nag-uusap pa lang kayo if he will take on the case. Because, you know, when a client goes to you, pag lawyer na kayo, client goes to you, intending to hire you, sasabihin mo agad, you lay your cards on the table so I would know what to do. O syempre, intending to take you in, intending to hire you, isasabihin niya lahat. That is privilege already. Kasi with the view to hiring you. So, nitatrust ka na niya eh. So, if nothing happens to your agreement, if you don't agree to take on the case, you're disqualified from testifying. Whatever has been relayed to you, even with the view to, even if no lawyer-client relationship has as yet been established. Okay. Not only in the course of, but likewise with the view to the professional engagement of a lawyer. Yung priest, it is not any statement made, kailangan daw, it must be made in the course of a confession that is privileged. The confession, please, is if any admission is made, for example, by a confessor, but it was not in the course of a confession, walang disqualification for the priest to testify. The priest will be disqualified only if any admission, for example, in the commission of the crime, was made in the course of the confession. Ang confession dyan is confession for the purpose of seeking absolution of one's sins. Confession for purposes of seeking absolution, forgiveness of one's sins. If, let's say, in the course of the conversation lang, sabi niya, alam mo, Father, ako naman talagang pumatay dyan. That is an admission. Question, is the priest disqualified from testifying on what he heard, on what the accused told him? No. Because that was not given as a confession. There may have been an admission, but it was given as part simply of a conversation. Malay mo, kung sinatsaring lang siya. So, it was not. What is the disqualification on the priest will attach if any admission is made in the course of the confession. Yung confession is for purposes of seeking absolution for one's sins. Okay. Itong hindi naman siguro sub judice, general lang ito, yung executive privilege. Yung executive privilege, yung Senate versus Ermita, sa 2006 case. Executive privilege na they refuse to testify. Di ba? Okay, yung concept niyan, it is EO, Executive Order 414. Which provides for the executive privilege. Sabi niya, the power of the government to withhold information. Executive yan, The power of the government to withhold information from the public, from the court, and from Congress. Information on military, diplomatic, and national security secrets. Yun lang, military, diplomatic, and national security secrets. Executive privilege, the power of the government, executive department to withhold information. Yan ang in-invoke, di ba? Kasi nakasampa na yung kay Neri. Siya nag-invoke niya, di ba? One of those who invoked that. Okay. Offer of evidence. Let me just call your attention, please, to offer of evidence. The rule is, the court shall consider no evidence that has not been formally offered. Di ba? That is the rule. Okay. Ngayon, recent jurisprudence now makes a qualification. Rule. The court shall consider no evidence that has not been formally offered. Okay. Exception. When the evidence, kasi sometimes the evidence is marked, identified in the course of the testimony. It is marked, it is identified, but it was not offered. Nagkaka-senior moments ang lawyer, nakalimutan i-offer. But it was marked, it was identified by the witness. Okay? So, since it was not offered, pasok yung rule. The court shall not consider that. Any evidence that has not been formally offered shall not be considered by the court in the evaluation, the determination of the case, resolution of the case. Okay? Exception. If that piece of evidence was duly identified by testimony, duly recorded and incorporated into the records of the case. The exception is the evidence must have been duly identified by testimony, duly recorded, and the same must have been incorporated in the records of the case. That is the exception. So even if that piece of evidence has not been formally offered, it will be considered. Kailangan lang it was duly identified by testimony, duly recorded. and it is incorporated into the records of the case. That is the case of heirs of Tabuena versus Land Bank, September 16, 2008. Heirs of Tabuena versus Land Bank of the Philippines, September 16, 2008. Okay, now, when do you make an offer? If you make offer of testimonial evidence, as I said, you offer testimonial evidence at the time the witness is called to the witness stand. You offer the testimony of the witness, you do not offer the witness. You offer the testimony at the time the witness is called to the witness stand. When do you offer object and documentary evidence? After all testimonial evidence have been given. Tapos na yung witnesses. I have no other witness to present. I'm ready to rest my case. You now offer object and or documentary evidence at the time all testimonial evidence have been presented. For every offer of evidence, we said you have to state the purpose for the offer. Why? Kasi pag in-state mo yung purpose, the other party would have to be given the opportunity to register a comment or objection to the offer of evidence. Okay, so kailangan you always have to state the purpose for the offer. Okay, so since we say that the other party may raise an objection to any offer of evidence, any offer of evidence. Now, the objection must be seasonably raised. When do we say that the objection must be seasonably raised? Under the rules, when the ground for objection becomes reasonably apparent, that is why you have to be listo, alert, sabi sa rules. When the ground for objection becomes reasonably apparent, you have to immediately, seasonably raise your objection, otherwise waived. Otherwise waived. Now, what about hearsay evidence? Sabi, in some cases, kasi, in some cases, sabi, if hearsay evidence is presented and it is not seasonably objected to, admitted daw. I've read a lot of cases like that. Pag yung hearsay evidence, pag your hearsay evidence is not seasonably objected to, it's like any other evidence that when not seasonably objected to, it is admissible. Because the objection is deemed waived and therefore admissible. But you should take exception with respect to hearsay evidence. Why? Kasi, hearsay evidence, di ba, whether objected to or not, basically inadmissible yan. Because, di ba, I laid the basis, for purposes of admissibility, it must be both relevant and competent. Hindi naman yan competent eh. Because it is expressly excluded by the rules. So, pag hindi, kasi the rule is, I think this is the exception. The rule is once a piece of, when the ground for objection becomes reasonably apparent, you have to seasonably raise your objections. Otherwise, wait. That would apply. Otherwise, wait. And therefore, the evidence is admissible. But how can it be admissible if it's hearsay? I just cannot find the case that I read to justify my conclusion na nakalagay doon. Hearsay evidence, whether objected to or not, is inadmissible. Because even if it is relevant, it is incompetent. And what are the requisites for purposes of admissibility? As I said, of any piece of evidence, it must be both relevant and competent. In that instance, magiging exception ng hearsay to the rule that when the objection becomes reasonably apparent, you have to seasonably raise your objection. Otherwise, wait. Hearsay evidence, therefore, whether objected to or not, is inadmissible. No weight can be given. Because it is incompetent. Okay, now, another point. Lumabas ito sa Barwa 6 years, 5 years ago. what are the different kinds of objection? Kasi hindi pa, next year pa yung multiple choice eh. Next year pa. So ngayon kayo, puro pa rin, objectives, problem solving, no? Okay, so yung what are the different kinds of objections? Just remember, no? You have to be prepared for anything in the bar. What are the different kinds of objections? Diba? The general, the specific, the substantive, the formal. General, specific, substantive, formal. Pag general objection, you do not actually say the basis. At least, for every objection made, you have to state the ground for your objection. Pero pag general, hindi ka nagbibigay ng specific reason for your objection. Objection on what ground? It is a legal ground when you say evidence is immaterial, question is immaterial, question is immaterial, irrelevant, impertinent, lahat ng that is a general objection. You do not actually say, why is it relevant? Why is it irrelevant? Why is it immaterial? Why is it impertinent? That is already a legal ground. That is a general objection. But when you say objection, it calls for an opinion. Specific, di ba? This witness has not been qualified. This is an ordinary witness. And under the rules, a witness must be, to give an opinion, he must be an expert witness. Or a witness, ordinary witness, under three circumstances. Di ba? When he has adequate knowledge of the identity of a person, if he is sufficiently familiar with the handwriting of a person, sufficiently familiar with the handwriting of a person, or he is sufficiently acquainted with the mental sanity of a person. He is an ordinary witness, but under those three circumstances, he may give an opinion. Paki-memorize yan under the opinion rule. An ordinary witness cannot give an opinion. The opinion of a witness is not admissible. Except, number one, if he is an expert witness. And number two, he is an ordinary witness, but he is asked for opinion under any of three circumstances. Paki-memorize yan. If the witness, even if he's an ordinary witness, he can give an opinion under three instances. If he has adequate knowledge of the identity of a person, if he is sufficiently familiar with the handwriting of a person, and if he is sufficiently acquainted with the mental sanity of a person. But whether he is an expert witness or an ordinary witness under those circumstances, before he can give an opinion, the proper basis must be laid. Pag expert, he has to be qualified. He has to be qualified as an expert witness. He has to be qualified as an expert witness. Okay. Now, pag ordinary witness, kailangan the proper basis has to be laid. Bakit mo kilala? Why do you say that you have sufficient knowledge of the identity? From birth, I was the one who took care of him. I know him. Even in pitch black, I can identify him. Kahit na kasing black siya ng condition. Kahit mas maitim pa siya kay Vice President. In pitch black, I can identify it. So, proper basis would have to be given for purposes of admissibility of that opinion. Okay, so, going back to the objection. Objection! The question calls for an opinion. That is a specific objection because you are specifically stating the ground for an objection. It calls for an opinion. This witness has not been qualified. Objection! Violation of the best evidence rule. The witness is now being confronted, being asked with respect to the contents of a document, but the witness is being confronted with only a photocopy of an alleged document. Violation, specific objection, specific ground. Okay. Formal objection, as distinguished from substantive objection. Formal objection, the objection is based on the defect in the form of the question. It is based on the defect in the form of the question. Objection, question is leading. Objection, question is misleading in the form of the question. Ano ba yung leading question? It suggests to the witness the answer which the examining party desires. After the incident, did you go to the police station to report? Yes, it's answerable by a yes or a no. That is leading. It suggests to the witness the answer which the examining party desires. Misleading question. Defect in the form. Misleading. It assumes as true a fact not yet testified on by the witness or contrary to what the witness has stated. Misleading. Or, so iba, formal. Objection. Question is kilometric. Gulat ako nun, erase yun eh. Yes, sabi ko. That is a formal objection based on a defect in the form. Short of saying, kailangan ang tamang objection dyan, question is compound. Nagulat kasi ako, what is the legal ground for your objection? Your Honor, the question is kilometric. Okay, sustain. Pero dapat ang ginamit niya compound. Pero pwede na rin yun, ina-atake niya yung form. Specific. This format. Now, on the other hand, if it is substantive objection, if it is substantive objection, the objection is based on the inadmissibility of the evidence itself. The objection is based on the inadmissibility. Objection! Calling for hearsay. Answer. Because the objection, the answer is hearsay. This witness is not testifying on a matter of his own personal knowledge. Okay, objection, violation of the best evidence rule. Okay, objection. But it is based on the inadmissibility of the evidence itself. That is substantive objection. Now, please take note of matagal nang hindi lumalabas. So I want you to be prepared for this, the concept of continuing objection. In continuing objection, under section 37, the questions are of the same class to which objections have been raised and ruled upon. So, in other words, it contemplates a situation where the question is repeated. Repetitive na yung pag-pose ng question. It is the same question that has already been asked. It is the same question that has been already asked and answered. If you raise an objection once, even if your objection has been overruled or sustained, nagkaruling na on that question. And therefore, if it is repeated, every time it is repeated, you don't need to always stand up and raise an objection. Sasabihin mo lang, Your Honor, I would like to register my continuing objection to the line of questioning of the adverse counsel. Tapos, that is a continuing objection to questions propounded which are of the same class to which objections have already been raised and ruled upon. Doctrine or principle of continuing objection. Same questions to which objections have been raised and ruled upon. Please remember, for every objection we said, you have to state the legal ground for the objection. Pag wala kang legal ground, you better shut up. Mapapahiya ka sa court. What is your legal ground? Mag-invento ka na lang and let the court rule. Sabi mo, immaterial, Your Honor, impertinent, overruled. Wala na. At least nakastate ka ng legal ground. Mas nakakahiya. Mas it happened. When I was a new judge, syempre fresh na fresh ako sa mga books, ina-apply ko. Sabi niya, forma siya, Arneo Objection, Your Honor. MTC lang ako nun, minamani ako Objection, Your Honor. What is your legal ground for your objection? Tagal. Counsel, what is the ground for your objection? Look at her, babae. Bigla sabi niya, I withdraw my objection. Amote kong gano'n. Ano the rules for every objection, kahit mag-invento ka para hindi ka mapahiya, you have to state and leave it to the court to rule on your objection. Now, comes the ruling of the court. Under the rules, remember, ito in-stress ko. The lawyer is under obligation to state state the legal ground for the objection, but the judge is not under obligation to state the basis for the ruling. That is, what is the ruling of the court on the objection? Sustained, overruled, sustained. Ganun lang. You don't question. Overruled. On what ground are you overruling my objection, Your Honor? You cannot do that. The judge is not under obligation to tell you what is the basis for his ruling. That is why ordinarily, the judge can rule on your objection even while sleeping. You cannot question, unless of course, your objection is founded on or is anchored on several grounds, in which case, the judge has to rule on why you're overruling on this ground, on why you're sustaining on this ground. But if there's only one ground for the objection, nagsabi ang judge, sustain, okay ka na dyan. Hindi mo pwedeng questionin yung ruling ng court because the court is not under obligation to state the basis for the ruling as far as objection is concerned. Now, ito, lumalabas na ito, striking out the answer. Because there are some witnesses, many witnesses for that matter, kasi nga rehearsed sila. Sabi, pag ito, madinig mo itong word na to, sumagot ka na agad. Trained yan rehearsed kasi he is a witness of the proponent. So the one questioning him is the one presenting him as the witness. Meron pa objection. Pag the witness gives an answer prematurely, hindi pa nakaka-raise ng objection. The court, if the court finds the valid objection to the answer given by the witness, which was prematurely given, without waiting for the other counsel to object, the court can order the striking out of that testimony. Hindi pa pwede. Kaya nagugulat ko, some lawyers would say, already answered, Your Honor. Sasabihin naman ng judge, okay, already answered, go to another point. Wrong. Because there's such a rule. Kasi baka valid yung objection The answer, in other words, the witness beat him to the throat. Nadinig niya yung word, yes sir! Kahit na hindi pa, you have to always caution the witness to wait for any objection. Pag walang objection, tsaka ka sumagot. But if you preliminary give, kailangan hindi mo sasabihin, hindi naman mag-acknowledge ang judge na already answered, go to another point. Wrong for the judge to do that. The judge would first have to listen to the objection. And if the judge is convinced that there is valid objection, the judge will have to order out the striking out of the answer given by the witness prematurely at that. So, striking out of the testimony. Now, offer of evidence is different from offer of proof. Yeah? Offer of evidence is different from offer of proof. When you talk about offer of evidence, yan yung sinasabi natin, offer of testimonial evidence, offer of object or documentary evidence. Offer of testimonial evidence at the time the witness is called to the witness stand. Offer of documentary object evidence after all testimonial evidence has been given. That is offer of evidence. Offer of proof is tender of excluded evidence. Okay, that is under section 40. Tender of excluded evidence. That is offer of proof. So when do you make an offer of proof? When do you make a tender of excluded evidence? After the court has already resolved the offer of evidence. Ulit when do you make an offer of proof or tender of excluded evidence? You do that, make an offer after the court has already ruled or resolved the offer of evidence. Kasi, tingnan ninyo, the court rules, I offer Exhibit A for the purpose. Objection, I object to the admissibility of Exhibit A. The court rules, Exhibit A is admitted. Exhibit B is denied admission. Exhibit C is admitted. Okay, please, once the court rules, rules to deny admission of one exhibit, that exhibit will no longer form part of the records of the case. Yun ang tandaan nyo. Once a piece of evidence that is offered is not admitted, it is denied admission, it will not form part of the records of the case. Ang matitira lang sa records, yung mga na-admit. Gets nyo? Okay, now, but you, the one who made the offer, firmly believe that that is a vital piece of evidence. Now, the last opportunity for you to make it form part of the records is this offer of proof. Tender of excluded. Na deny admission, din exclude, di ba? So, tender of excluded evidence. Your Honor, Exhibit A has been denied admission. May I nevertheless request that it be attached to the records, or that it remain in the records of the case. The testimony of Mr. X has been disqualified from testifying, Your Honor. Had that witness been allowed to testify, bigay mo in personal circumstances, had that witness been allowed to testify, he would have testified on the following matters. Pinasok mo. I'm now making an offer of proof, Your Honor. Exhibit A, which has been denied admission, may I request that it be attached to the records of the case. Exhibit, the testimony of this witness was been disqualified from testifying. He would have testified on the following points. Pinasok mo pa rin sa records. I'm making an offer of proof. Why? For what purpose? Pinasok mo sa records for purposes of appeal. Please take note, kasi pag in-appeal yan, di ba na-review yung entire records? Kung wala doon yung evidence mo, so this is the last opportunity for the person whose evidence has not been admitted to actually put it into the records. Ang purpose niyan is for purposes of appeal. Gets niya? Offer proof, tender of excluded evidence. Now, before we leave testimonial evidence, let me just refer you to yung sabi niya, a witness can testify only on matters of his own personal knowledge. Yeah? He cannot testify on any matter of fact that has simply been relayed to him by a third person. Because if he testifies on a matter which is simply relayed to him by a third person, that testimony is hearsay. Very important kasi yung concept ng hearsay. So, number one, why is hearsay inadmissible? Because of that rule. Hearsay is inadmissible because a witness, as a rule, can only testify in matters of his own personal knowledge. If witnesses on the witness stand cannot say, according to X, Y is a rapist. I will not be competent to say that Y is a rapist. Why? Because I have no personal knowledge. So, a witness can testify only on matters of his own personal knowledge. That is one reason for the inadmissibility of hearsay. And number two, because of the absence of opportunity for cross-examination. Because of the absence of opportunity for cross-examination. Kasi, what is the purpose of cross-examination? The purpose of cross-examination is to test the credibility, to demolish, diminish the credibility of the testimony of a witness. And let's say, wala doon yung witness on the witness stand. Patay na yung witness. Or insane na yung witness. Who can no longer testify. Can you test the credibility of someone who's already dead? Of someone who can no longer testify because he's insane? Absence of opportunity for cross-examination to test the credibility, wala na. Therefore, that is hearsay. In fact, remember, even if a witness has executed an affidavit, even if a witness has executed an affidavit, even if that affidavit at the first instance was subscribed and sworn to before a prosecutor or before a notary public, for as long as that witness is not presented in court for that affidavit to be put, for as long as the affiant of that affidavit was not presented in court and not subjected to cross-examination, that affidavit is hearsay. In at least two cases that I read, it's 2009, the doctor who prepared and executed the medical certificate was not presented in court. The doctor who was not presented in court. Sabi ng Supreme Court, that medical certificate is not admissible for being hearsay. Why? Because the one who prepared that and who was not presented in court, hindi mo matetest ang accuracy of the contents. So that is hearsay, that document. Now, it may be argued, sabi, it may be considered as an entry in the ordinary course of business, in the performance of the duties of the doctor. Tingnan niyo to, ang ganda ng 2 case na to Yung medical legal medical. Kasi this involved a prosecution for murder. He was convicted of murder with the attending circumstance of treachery. Sabi niya, clutching on straws na siya. It was shown, it was established that he was the one who killed the victim. Sabi niya, okay, but you should not have appreciated treachery against me to qualify the killing to murder, because I was able to present psychiatric evaluation report stating that before, during, and after the incident, I was suffering from psychosis. Meron siyang mental deficiency. Meron siyang psychosis. And therefore, ang treachery, di ba, the mode of attack must have been consciously adopted by the killer. The mode of attack must have been consciously adopted by the perpetrator of the crime to avoid any risk arising from the defense which the offended party or the victim may put up. Di ba yun ang concept ng treachery? The mode of attack must have been conscious. How can you say that there was treachery? How can you say that I have consciously adopted when I was diagnosed to be suffering from psychosis? Clutching was close to siya. I was diagnosed to be suffering from psychosis. Nandyan ang medical evaluation report ko. Psychosis before, during, and after the commission of the crime. So I could not have consciously adopted. I may have killed him, but I did not consciously adopt the mode of attack. And therefore, treachery cannot be. Gusto niyang bumaba eh. Pag homicide kasi, di ba, reclusion temporal? Pag murder, reclusion perpetua. Okay, so, pinabababa niya. What did the Supreme Court say? Number one, the doctor who conducted the alleged psychiatric evaluation and who prepared that medical legal report was never presented in court. So that report is hearsay. Now, sasabihin mo, it may be argued, sabi sa Supreme Court, that it is an entry that is made in the course of the performance of the duty by the doctor. But it cannot even fall under exception to the hearsay rule. Why? Kasi yung entry na yun is considered as an opinion. Kanya ang ganda eh. Ang galing ng Supreme Court. It is considered as an opinion of a doctor, correct? Kasi report ng doctor yan who was never presented. Now, so, since he was never presented, and it is an opinion, hindi ba for an opinion to be admissible, kailangan, it is an opinion of an expert witness. Kaso nga, hindi na qualify yung doctor. Wala yung doctor. So it's still not admissible. Not only on the ground of hearsay, but likewise on the ground of opinion. Because the doctor was never presented, was never subjected to cross-examination to test the accuracy and credibility of the contents of the medical legal report. Ganda, no? Connect. You may be confronted with problems like that. Okay. Now there are, however, exceptions, di ba, to the hearsay rule. One very important exception is dying declaration. Yung mga important exceptions, dying declaration, res gestae, declaration against interest, testimony, deposition at the former proceeding. Ito mga importante. Yung iba lang importante, but it does not need explanation or emphasis. Dying declaration declaration, please remember, for it to be admissible, even in the absence of cross-examination na ito, exception to the hearsay rule. Meaning, kahit na hearsay yan, because of the absence of cross-examination, dahil patay na, or unable to testify, then it's still admissible, even in the absence of cross-examination. Kailangan, the declaration must have been made under consciousness of an impending death. The declaration must have been made under consciousness of an impending death. What do you mean by that? Under consciousness of he actually, at the time he made that statement, at the time he made that declaration, he actually believed that he was dying. At the time he made the declaration, he actually believed that he was dying. Gets niya? Okay. Consciousness of an impending death. The declaration can be used to establish the surrounding circumstances leading to his death. And the witness would have been a competent witness had he been alive. Okay, for purposes of dying declaration. Sabi, ano ang rational? Why is it admissible if it's a dying declaration made under consciousness of an impending death? Even if there is no more opportunity for cross-examination. Even if it is basically hearsay, why is it admissible? Kasi daw, di ba, rationale behind this rule is a person who is dying and who believes himself to be dying will no longer tell a lie. Because he believes that once he dies, and he is lying when he dies, he will go straight to hell. So, kaya admissible. Kasi takot siya mag-lie. Yun ang rational dyan. But it must be shown that he actually, at the time he made that, kasi several stab wounds, tinanong siya, who did this to you? Dying declaration yun. At the time, talagang, obviously, he believed that he was dying. Kahit na namatay na siya, pwede ma-admit yun. Kasi it was made under consciousness of an impending death. May isang case, no? It's a 2008 case. He made it, hindi naman siya tinanong. Because there was one isolated case, no? Do you believe that you're dying? Dami niyang wounds. Was brought to the emergency room at the hospital. Do you believe that? Who did this to you? Si Mr. X. Do you believe that you're dying? Para pumasok sa dying declaration, in the event that he dies. Do you believe that you're dying? Sabi niya, unpublished ito. Sabi niya, I think so. It was not considered as a dying declaration. Kasi para daw lumalabas doon, umaasa pa siya na magbubuhay siya. Kailangan dyan, it must have been made. Yung isang case, yung sabi itong 2008 case, while he was identifying his assailant, he was already gasping for breath. Ang dami na niya tama eh. He was already gasping for breath. He was lifted. He was lifted to be brought. Hindi na siya nakarating sa hospital. DOA na siya. So sabi ng Supreme Court, he made it under consciousness of an impending death. Because when he was making it, he was doing like that. He was gasping for breath. Obviously, he was dying. He wanted justice. Okay, now, here's the prosecution. He identified his assailant, but he did not die. He made the identification of his assailant under consciousness of an impending death, but he did not die. Dahil masamanda mo siya. In a subsequent prosecution for frustrated homicide or frustrated murder, as the case may be, subsequent prosecution for frustrated homicide or frustrated murder, as the case may be, can the declaration of the victim made by him at that time under consciousness of an impending death, can it be utilized in evidence against the suspect, against the accused in the subsequent prosecution? Can it be used in evidence as a dying declaration? Because it was made by him under consciousness of an impending death. Who did this to you? Ang dami yung saksa. Who did this to you? Si Mr. X. Siya ang naggawa nito. Okay. But he did not die. He survived. Subsequent prosecution for frustrated homicide and frustrated murder, as the case may be. Can that declaration of the victim, of the offended party, made by him under consciousness of an impending death, can it be used in evidence evidence against the accused in this particular case based on that incident as a dying declaration. No, it is not. It cannot be used in evidence, even if it was made under consciousness of an impending death. Why? Hindi siya namatay, no? He survived. Therefore, it can still be used in evidence as part of res gestae. Part of res gestae. Please, okay na kayo dun sa, there are actually two parts, no, of res gestae. One, spontaneous exclamations, part of res gestae. Two, verbal acts. Madali lang yung spontaneous exclamations, di ba? Statements made by a person while a startling occurrence is taking place, or immediately before or immediately after the occurrence, after the startling occurrence. So, example natin, di ba? It was immediately before, immediately after the startling occurrence when he made that dying declaration. Okay, startling occurrence. It must not be, for example, it must not be death by natural causes or he got sick. No, it must be startling. Binarel, sinaksak, nasagasaan. These are startling occurrences. Okay, so spontaneous exclamations. The statement, you don't anymore make use of judgment in the determination of what is happening. Sinasabi mo na lang, spontaneously. You're verbalizing what you see. Yung mama, ni bububog. That is verbal act. Spontaneous. Yung babae, ni-rape. That is spontaneous exclamations. No problem kayo that. Nagkakaproblema sa verbal acts. Please, tandaan lang ninyo ito. Statements accompanying an equivocal act, giving it legal significance, that is also admissible as part of res gestae. Ulit statements, say verbal acts, statements accompanying an equivocal act, giving it legal significance. Yan ang verbal acts. So, if you're confronted with a problem, sasabihin sa, is it part of res gestae? Titignan ninyo, pag walang startling occurrence in the problem, baka pumasok sa verbal acts. Now, pag pumasok sa verbal acts, tignan nyo kaagad if the act is equivocal. What is equivocal? Yung ba subject to different interpretations? Is ambiguous. Hindi mo alam kung ano talagang purpose ng performance of that act. That is equivocal. And then find out if there's a statement that accompanied that equivocal act. In which case, that is verbal act, part of res gestae. Remember, in your undergrad, and I gave an example. This is the simplest I can go. If all of you see me hand over to him a bundle of money, all of you see me hand over to him a bundle of money, but I am not saying anything. Hindi ba my act of handing over to him the bundle of money is equivocal? Why is it equivocal? Because you do not know. Without me saying anything, you do not know what was my purpose in handing to him the bundle of money. Nakita lang ninyo, I'm handing it to him, the bundle of money, but you do not know. Why am I handing to him the bundle of money? It could be that I'm handing to him the bundle of money because I'm paying him back, or he was earlier borrowing from me. Wala. So, that is equivocal. Now, if all of you see me hand over to him the bundle of money, and at the same time, nadinig nyo while I am handing over to him the bundle of money, you hear me say, ito na yung niuutang mo kanina. Di ba? My statement gave meaning to my otherwise equivocal act. Pakitago mo nga, kukunin ko sa'yo. So, my statement gave meaning to my otherwise equivocal act. Without my statement, hindi nyo alam kung anong purpose ko, correct? That is verbal act. Exception to the hearsay rule. Verbal act, res gestae. Clear ba? Clear? Uy, baka lumabas eh. Another important exception to the hearsay rule, of course, is declaration against interest. Ang ano lang dito, if the person makes a declaration against his own interest, kasi di ba, a person normally does not say anything bad about himself. Normally, he does not say anything incriminatory of himself. Kung pwede niya ilagay ang sarili niya sa pedestal, he will do it. So, if he says something that is against his interest, and subsequently he dies, that is admissible, even if it was not tested on cross-examination. Why? Because a person normally will not say anything incriminatory of him. So, if he says something against his interest, if he says something incriminatory of him, that means there is some truth to that. Kasi abnormal yun eh. Kahit na ang pangit mo, sinasabi mo, maganda ka eh. Kahit hindi ka matalino, sinasabi mo, matalino ka. Because you wouldn't want anything incriminatory or something that would put you in a bad light. So, abnormal yun. That's why if you say something against your interest, you would not have said it if you did not believe it to be true, correct? So that's logical. Therefore, if after having said something against your interest, namatay ka o nasira ang dente ng tok-tok mo, that is admissible even in the absence of cross-examination. Isa pa, testimony. Kailangan talaga lang kasi for a declaration to be admissible, it must have been subjected to cross-examination. It must have been tested on cross-examination. Now, if it is not tested on cross-examination, then it is hearsay, absence of cross-examination. Isang very important exception here is testimony or deposition at the former proceeding. Testimony or deposition at the former proceeding. Okay. Tingnan niyo ito, the testimony or deposition of a witness, deceased, or unable to testify, given in a former case or proceeding, judicial or administrative. Either way, if the witness gives testimony or deposition in one proceeding, it can be involving the same party in another proceeding, involving the same parties, the same subject matter. It may be given in evidence against the adverse party, alam naman, who had the opportunity to cross-examine him. One case, nagbigay ng testimony yung witness. In one case, after the witness gave testimony, he died or became insane. So hindi na mako-cross-examine yan. Question, can that testimony of that witness, so can no longer be cross-examined, because he died after he gave the testimony, can that be utilized in evidence in another case involving the same parties? Can that be utilized against the adverse party in another case? It all depends on whether at the time the witness gave the deposition or testimony in the first case, there was cross-examination or there was opportunity of the adverse party to cross-examine. Pag hindi na cross-examine, dun sa first case, hindi mo pwedeng ipresenta yan as evidence against the adverse party in the second case. If there has been cross-examination in the first case, pwede mong introduce in evidence in the other case, whether it is judicial or administrative. Kailangan lang talaga absence of opportunity for cross-examination, hearsay, inadmissible. But for as long as there is cross-examination, for as long as there's been opportunity to cross-examine in the first instance, pwede yan i-introduce na matay na, hindi na pwede ma-cross-examine in the second case, it will be offered. It may be offered in evidence. I will have to discuss this because it's very important. This is very important in character evidence. Please take note. You can present character evidence only if it is pertinent to the character involved, to the moral trait involved in the case. If it is pertinent to the moral trait involved. In criminal cases, sabi dito, because the rule is, character evidence generally not admissible. Kasi merong specific instance lang eh. If the moral trait of the person is not involved, you cannot present character evidence. Now, in criminal cases, sabi dito, the accused may prove his good moral character, which is pertinent to the moral trait involved in the offense charge. Now, ito ang second paragraph. Lagi ko ini-stress to. Take note, unless in rebuttal. Unless in rebuttal, the prosecution may not prove the bad moral character of the accused, which is pertinent to the moral trait involved in the offense charge. Very important yan. I think I gave emphasis to this when you were in the undergrad. Sa review, diba? Unless in rebuttal. First question, when is the rebuttal? Step by step natin para matandaan nyo. When is the rebuttal? Diba after the accused has rested the case? Ano ba yung order of trial? Prosecution, defense. Rebuttal for the prosecution, so rebuttal for the defense. So when is rebuttal? After the accused has rested his case, correct? Okay, so if the accused interposes a negative defense, who starts presenting evidence first? The prosecution. Kasi magkakaroon lang ng reverse order of trial if the accused interposes an affirmative defense. Kasi nasa kanya ang burden. Di ba? We get to that. Whoever asserts the affirmative has the burden of proving that affirmative assertion. Okay, so, accused interposes a negative defense. I did not do it. Negative. So, prosecution presents evidence. After the prosecution rests, the defense. After the defense rests, the rebuttal for the prosecution. After rebuttal for the prosecution, so rebuttal for the defense. Okay, nakalagay dito, unless in rebuttal, the prosecution may not prove the bad moral character of the accused, even if it is pertinent to the moral trait involved in the offense charge, which means that at the time of the presentation of its evidence in chief, even if the prosecution has a truckload of evidence to show that the accused is a person of bad moral character, hindi nila pwedeng i-presenta yan. It is only when the accused presents evidence that he is a person of good moral character and therefore he could not have committed the crime attributed to him. Hindi ako dishonest na tao. Napakabait ko. Ipipresenta niya lahat ng tao sa barangay to prove that he is such an honest person. He is such a religious person. He goes to mass. He goes to mass every day. Pamatbay niya 1 kilometer away from the church. He goes there, kneeling down. Super bait yan. He presents evidence of his good moral character. He presents evidence he is a person of good moral character. Therefore, he could not have committed the crime attributed to him. It is only then when the prosecution now can be allowed to present evidence that to rebut the claim. But if the prosecution starts to present its evidence, the prosecution has the burden of proving the guilt of the accused beyond reasonable doubt. The burden is to prove the essential elements of the crime charge and that the accused is liable for that particular crime. Hindi nila masasatisfy ang burden of proof nila by simply saying that this person is a person of bad moral character and therefore he did it wrong. So the only time when the prosecution can present evidence of the bad moral character of the accused is when the accused presents evidence of good moral character. If the accused does not present evidence of his good moral character, it's not part of his defense, and so therefore he does not present evidence of his good moral character, hindi pwede magpresenta ng evidence ang prosecution that he is a person of bad moral character. That is very important as far as character evidence is concerned. Gets nyo? Okay. Now, 5 o'clock, I will stop, ha? Sakit na eh. Klase pa ako. Anyway, we have tomorrow and next week pa. Yeah, tomorrow. Yung mga, alam ko may tomorrow and another day. Likely lang kasi yung provisional remedies eh.
Until Friday.
No. Hindi, nilipat. Friday, I'll be in Cebu. I have my review in Recoletos.
It wasn't announced.
No, tomorrow. Pero tomorrow meron, di ba? Tomorrow, and then it was moved to 27. Kasi I have a previous, review. I'll be leaving Friday after lunch for Recoletos. Sa iba ako magra-rocket eh. Recoletos, I'll be there overnight. I'll start 4 to 9 and then 8 to 2. Then I'm back in Manila. So hindi ako pwede. Pinalipat ko yung akala kayo na 27.